attending today. We have a lot to cover. It's one of the most really complex decisions in asset protection and corporate structuring work is the entity selection. There's a number of entities in the states. The various states have different entities, different strengths and weaknesses, as well as offshore. Now we have a number of jurisdictions to choose from in terms of where we're going to form trusts and essentially LLCs. For the agenda, we'll introduce you to the issues, which are fairly straightforward. We'll also discuss some of the titling and related issues associated with what type of corporate entity to choose and how to integrate trusts into a protective structure, as well as some of the tax issues. Note that we will have some technical tax issues I'll try to cover at the end. It's a lot of material, so it'll be pretty much an overview. If you have a question, there is a chat, and Tony will let me know if we have a question. I think I also see the question. In any case, we'll answer the question right in the middle whenever you have it, no problem. Because we change topics so much, go ahead and just ask the question when we're in the particular topic. Then we'll get into LLCs. What are some of the considerations? Which jurisdiction should we use and why? It's not always the same jurisdiction for a particular corporate or planning matter. Different jurisdictions have different characteristics, which you have to be aware of given the particular situation. That's related to this choice of law issue. Single member LLCs, we all know that that's become kind of an avoidance issue. Different jurisdictions have actually addressed the court problems associated with single member LLCs. Others have not addressed it. Others have caved, like Florida. So for Florida, for instance, you want to avoid the single member LLC. We'll get into that. Offshore options and developments, and then we'll talk about how to use classic trusts as well as some of these domestic asset protection trusts. When are they good? When are they not good? And then the foreign counterpart, the foreign asset protection trust. And then we'll hit some of the tax considerations in an overview. The tax considerations, actually, we have done a number of seminars on tax considerations for trusts, and they're available on our YouTube channel as well. That's a separate detail if you want the detail on the trust and the tax considerations. And then we'll wrap up with any further questions. In terms of an overview and introduction, the idea with a lot of this asset protection work, people don't consider corporate structuring asset protection, but essentially it's the same idea. I mean, the reason for a corporation is to operate your business. If you operate your business and you take on debt or create internal responsibilities and contracts, you're not liable for what happens in the entity. That's why people use corporations. LLCs offer a different level of protection, and so do trusts. But corporate-wise, we use all three. The idea, though, is it's not a hiding. We're not avoiding anything. The reality is that when we do structuring, or when any competent practitioner does any protective structuring, that we want to disclose it. If we come into a problem and we're in litigation, or we're being looked at, or we have an IRS issue, or whatever we're doing, we want to share the structure in general with opposing counsel, whoever's asking to reach our assets, because we're protected. The law protects us specifically for the purposes that we're engaged in. We're not trying to put assets in a place that people can't see them. We're trying to put assets in a place where people can see exactly what we've done, and because of what we've done, those assets are not available to the creditor. I can't state that enough. I know we have 50 or 60 CPAs on the line, and the idea is not. Sometimes we get odd questions in the seminars where, why are we doing things where we wouldn't pay our debts? It's not that we're doing things where we can't pay our debts. It's that we're operating in a structure, both corporate wise and to a large extent personal, where we are legally utilizing the law such that the assets are in their most protective status.
So Gary, one of the questions that has come up is just, can you talk about the reasons to avoid a single member LLC in Florida? I've heard it is a limit to creditors' ability to collect distributions versus LLC assets. Can you just make sure you cover that? That was one of the questions that someone had sent in.
Yeah, absolutely. We'll cover that. That's and it's been 2 or 3 slides from now. The short answer on Florida is that Florida had a statute that didn't talk about single member LLCs. There was a bad actor named Olmstead who had single member LLCs, and the Florida Supreme Court pretty much obliterated any protection of the single or any other LLC. And then so the legislature had to come back in, but the banking lobby was very strong. So the legislature came back in and protected the multi-member LLC, but not the single member LLC in Florida. And we'll cover some of the details on the different states and offshore in a couple of slides. The one thing we wanted to make sure people were aware of were the 4 basics of asset protection. That's titling, exemption, exempt assets, I should say. It says exemptions. And then trusts and LLCs, which we'll expound on. Of particular importance with the structuring in terms of LLCs and trusts is the titling. So it's a combined approach. In other words, a great example that comes up almost every day is, for instance, we had a big construction group yesterday have us look at their structure, and they don't have an LLC, so we're going to convert from corporate to LLC status to provide them some protections. But they also had the company titled, it was a family company, and it was titled husband 50% and wife 50%. I'm simplifying a little bit, but it was titled husband 50%, wife 50%. So if husband is sued in a car accident, husband loses 50% of the company. If wife is sued, wife loses. If they're both sued, they lose the whole company. That's the corporation. If they had titled the corporation, or now the LLC, which is more protected, but we still rely on some titling. This is it's like a hot button issue. So if you see it, you'll realize that there's a problem. The husband and wife can title in Florida, and not all states, but in Florida and in states that allow tenancy by the entirety. Typically the tenancy by the entirety states, so you have a general overview, are not the community property states. So you have tenancy by the entirety in Florida. So what that does is it allows you to title together under the right circumstances. And the titling together prohibits one spouse to be sued and lose the stock or the LLC interest. The claim would have to be won against both spouses. That's titling. That's a huge issue in Florida. There's titling associated with insurance policies and annuities, all kinds of different titling. There's the homestead. That's a statutory protection, but it sometimes involves titling. And exemptions are these exempt assets, like a homestead, life insurance, annuities. So it's not just the asset, it's the title to the asset. It's not just the LLC, it's the titling to the LLC. Just something to keep in mind. It comes up all the time. It's a basic, but it's significant. In terms of basics on entity protection, here, this slide's on corporations. Corporations are formed because what you do inside the corporation, if you don't engage in any fraud or abuse, and you segregate, you don't treat the corporation as your personal piggy bank. That's this misuse or alter ego here in 3 little I in the slide. If you don't do that, you don't do fraud, basically you're going to operate the entity. The entity is going to have its own responsibilities, its own debts, its own AR, its own accounts payable. And if you have an exposure inside a business exposure, it's the shareholders are not liable. This comes up all the time. I actually had some questions the other day. Well, if it's an S corp, am I liable? No, you're not liable. S is a tax status. It has nothing to do with the state law protections. The tax status, it's very common that we kind of move back and forth between, well, what are the state law protections or the offshore protections versus the tax status. So the IRS went through this thing, and you know, they call it corporate S corp status, C corp status, partnership status, sole proprietor status, disregarded status. Unfortunately, they use the words corporation and partnership, and those are entities, but that status really isn't related necessarily to the entity, the actual characteristics, corporate characteristics of the entity, the state law characteristics, something that you should keep in mind. They always have to be looked at separately. So we're going to move into, I'll probably move through these pretty quickly, these LLC slides, because we've got so much to cover. But the corporation offers this inside asset protection. What happens inside, the shareholders are not liable for. But outside, if a shareholder is sued in a car accident or an outside investment, you lose the stock. That's it. It's totally unprotected. You can ameliorate some of that and some of these old school shareholders agreements by allowing, like if stock is attached and is going to be taken, the other shareholder can purchase the stock. That doesn't really, it's not a great solution a lot of times. You know, okay, I'm going to purchase your stock. Well, okay, we're still 50-50 part. Well, how does that solve my problem? And my wife's not happy or my husband's not happy. You know, it doesn't really work. So you really have to convert those corporations to LLC status, because the stock's totally exposed. So once you're an LLC, you get the outside protection, which is outlined in this slide. The outside protection means that if someone sues an owner, they can only get a lien. They can't vote. They don't own the stock. It's just a lien on any distributions. That's not a lien on wages. So wages keep getting paid. It's a lien on distributions. It's not good. It's not good, but it's a lot better than losing your stock. Going back to titling, one of the ways to ameliorate the lien is to hold husband and wife. Then both spouses have to be sued to be subject to the lien. That's outside protection. It's not exactly a protection. It's just a limitation on how a creditor can get to equity. So in a corporation, they take the equity. In LLC, you can be liened, but that only means if you make a distribution that the lienor, the judgment holder, gets paid. So what do you say? Not making any distributions. Don't have to make distributions. And it creates settlement, and typically the settlement is substantially less than the outstanding lien.
Gary, we have another question. If you have a Florida limited liability company owned 100% husband and wife as TBE, is that considered a single member or multi-member LLC?
There's no ruling on that, Tony. So what happens is, so we take this tax law is separate from the state law. So the tax law says, the guidance is that if you own stock together in a community property state, which is like a California Midwest type state, then you can elect to be looked at, viewed as a single member or disregarded LLC for tax purposes. Florida's not a community property state. So in Florida, the IRS is going to view that as more than one owner. That's the tax side. On the corporate side, it's if husband and wife hold together, it's it should be a multi-member LLC, but they hold together by the entireties in undivided interest, and we have no ruling on it. We have a California ruling, Corchi, which we will hit in a few slides, that suggests that if it's abused, in other words, that ruling was not a TBE because they don't have the TBE. That ruling was, okay, it was husband 99, wife was 1%. No. Wait, we're not going to go for that. It's husband, it's a single member. We're going to allow, we're going to expose the equity. So we don't have a ruling. So we very rarely suggest, we like the TBE and we like the LLC, but if we can, we like, if there's children, we like to add at least a trust for each child. It's also a lot of times a really good idea to start planning with these trusts, and that very likely will be adequate to create the multi-member LLC situation. So that's kind of the answer to that question, which I realize is not really an answer, but we just don't have them from the courts. On item 3 of this slide, it brings up a pretty interesting issue that's become very prevalent. So where we're pretty comfortable with this multi-member LLC issue in terms of adding a trust. Is it a multi-member LLC? Then the exclusive remedy is this lien, which is this charging order. If it's a single member LLC, it's going to depend on the state, which state is going to protect the single member LLC by statute. The way they do it is they say that the LLC charging order is the exclusive remedy. There's no other remedy. And some states even say, including the single member LLC. Florida is not one of them. Florida went the other way, actually says it's not protected. Delaware, South Dakota, several of these jurisdictions have that language, and we suggest that when it's applicable, when we can actually use that statute. This is some historical stuff on charging orders. This is how charging orders came about. They came about because corporations were viewed differently than partnerships. We used to have a handshake partnership where there were no documents. It was just a partnership. Everyone was liable for whatever happened in the partnership. You never want to do this. That developed into limited partnerships and limited liability. Limited partnerships, the limited partners were not liable for more than their investment, and the generals were liable, so they came up with this limited liability partnership that says now the generals aren't liable, general partners aren't liable anymore. They all got very archaic and became a relic when we got to the LLC, because we don't really have to go through that process because nobody's liable. Nobody's liable for internal problems like a corporation, but we also get the charging order protection. For a while, we were looking at limited partnerships in Florida. We still are once in a while because we don't like the we don't like the precedent. We don't like the precedent that occurred with that Olmsted case. But I think the statute's pretty clear now. We use limited liability companies pretty much exclusively as long as we can have a multi-member. And these are some of the protective features of the partnerships. This is kind of restating what I already went through. There's no voting right transfer if someone sues you. There's no annual minutes, which is kind of nice, like we used to have with the partnership. And the veil piercing, I'd say the veil piercing still exists if you abuse the LLC, but we try to, obviously our clients try to stay away from that. It's a hybrid entity. So what's happened is you get the internal protections of things that happen inside the LLC. The owners aren't liable for, and then you also get this outside protection, which is this limitation on a lien if someone sues an owner. This slide goes through some of sometimes when a company we have that's going to move to a public trading position, which is obviously a very small number of companies out there, you may move back to a corporate format. It corresponds better with a public offering. And then you get into where to form the LLC. Raises a whole list of questions. the reality is Florida has a pretty good multi-member LLC now. Delaware, Nevada, South Dakota are better. So if there are no issues at all, we often use Delaware or Nevada. Delaware is anonymous, which is not true of any other state. So some people like the privacy. If there's no other drawback to a structure, we'll use Delaware because we can file and there's nothing on articles. There's just no public disclosure. And then we can integrate that Delaware into either a national operation or a Florida operation. We could just file to do business in Florida. Sometimes it kind of obfuscates it because we don't do Delaware if we have to file to do business in Florida, because the filing to do business in Florida is kind of a pain in the butt because it requires some disclosure. So it depends on the situations. The various state protections depend on which act was adopted. They've been adapted to each state, but which act was adopted. The different acts have different protections. If we wouldn't use it, but some states actually allow for foreclosure of the charging order, which is very confusing. So if a member is sued in Florida, for instance, that's it. They get a charging lien. If distributions go out, they go to the individual with the judgment and the charging lien. Some states say you can foreclose the charging lien. Some states suggest that then you can take the equity. That's not really what it means. In Florida, you could take the equity of a single member. You can foreclose it out. Some states, what they mean by foreclosure of the charging lien you can't take the equity. It means you actually obtain a different ownership interest. It's in the charging lien. You could sell the charging lien, for instance, type of thing. It's very confusing. You want to stay away from these jurisdictions where they allow foreclosure or taking of a charging lien, as well as, because I know most of the people on the line are in Florida. We have a number of people internationally as well, but in Florida, we just want to stay away from the single member LLC, which allows that foreclosure right. A lot of this has to do with what's called the internal affairs doctrine. The internal affairs doctrine says if I'm in Florida and I use a Delaware LLC, Florida, and it has a statute on it, Florida, will respect the internal affairs of the Delaware statute, which we don't know if the charging lien is an internal affair. In my opinion, it should be. It's kind of like if I buy a Delaware nickel, I get the Delaware nickel. I get the Delaware protections and everything else in the Delaware statute. So it's just as a technical point, a lot of people ask this question, well, how do we know which law is going to apply? Well, it's this internal affairs doctrine. How will a court say, okay, the internal affairs doctrine says you can choose any entity you want and we're going to respect it? Sometimes they do, sometimes they don't. Surprise. There's a few examples. This Wells Fargo example is an interesting example of what you shouldn't do under any circumstances. Sabrina Barber racked up I think it was 64 or 65 million dollars of debt, went out on a real estate buying frenzy. It all collapsed on her. She had a lot of cash though. Believe it or not, in Florida, you have some options because the homestead is not subject to what's called the Fraudulent Transfer Act. That's the act that would unwind her transfer of cash at the time there's a judgment against her. So you can't wait until you have problems to do asset protection planning. That's what she did. She moved some assets into a Delaware account. There are some protections in Delaware, which are pretty interesting, not in a fraudulent transfer scenario per se. She moved a lot of cash into a Nevis LLC. She actually took money out of a Florida homestead, which was idiotic because that was actually protected. And the court looked at the Nevis transfer. She's in Florida. All of the assets were in Florida. She opened a Nevis LLC, but her accounts were in Florida. In my opinion, the move for the court kind of had an easy decision because it was a fraudulent transfer. So you apply the Florida Fraudulent Transfer Act, you unwind the transfer, you bring it back into her name, and you assign it to Wells Fargo. They didn't do that. What they did was they said, well, it's a Nevis LLC. You guys have argued all these I can tell you it's very protective. I wrote part of that statute. It's got to be put into effectiveness in a prudent way. It's not meant for fraudulent transfer. It has some interesting provisions in it. They basically said, well, you're here, so we're going to call it a Florida LLC. This actually happened. They call it Florida LLC, and she's a solo, so it's a single member. We're just going to take everything out of there. And, you know, financial planner, whoever's holding the assets, stockbroker, give us the money. And they did, and she lost horribly. Asset protection planning, either on the corporate or the personal side, is not meant to start engaging in, getting excited, transferring things everywhere once you have problems. Once you've defaulted, it's over. A lot of people think that, no, I don't have a judgment yet, I can do, no. Once you've defaulted or there's a problem where you left the scissors in the patient, it's over. There are some distinctions between once you've defaulted and once there's a judgment against you in the law. It's even harder to deal with it once there's a judgment. But once you've defaulted, asset protection planning becomes reactionary. It's not planning. A lot of the options, almost all the options, go away. The contrary case, it's just an interesting academically, this JP Morgan case. When you file the LLC in the right jurisdiction, it's pretty significant. In this case, it wasn't a fraudulent transfer case. There was activity, or there was a real estate dispute in I think it was Arizona, but the LLC was properly formed in Colorado. So what happened was the Arizona court ruled, there was a judgment, and I don't know, I'm not sure it's that clear in the case why, but the collection then was moved to Colorado. It's because it's a Colorado LLC, but that wasn't necessarily a great move, because now we have a Colorado court ruling on a Colorado LLC. Is that LLC protective of its assets? And the Colorado court's going to go with the Colorado statute. And it turned out that the Colorado LLC was protective of its assets. Probably not a great move. I don't know what the details of it, but to sue in Colorado, because the Colorado court will in general protect its own LLC. A similar outcome in Arroyo's, even stronger in some ways, where there was the dispute in Maine, and the judgment was recorded in Alabama, and I believe it involved a Delaware LLC, and the Alabama court was not comfortable with dealing with the Delaware LLC. The way it works technically is that the Alabama court could rule on whether or not the LLC was protective, and then it would decide, do I use Alabama law, which is what they did in Florida on that Nevis issue. I think it was a mistake. Or do I rule in Alabama using the Delaware law? They can rule based on Delaware law applying. They wouldn't do it. They actually ruled that the fact that the LLC was formed in Delaware pretty much eliminated the ability of the Alabama court to even rule on the entity. So that typically would go back to Delaware, and then that's very debtor friendly, because the Delaware court is going to come back and say, Delaware protects this entity, its assets are not available. So that's a very protective case. Go on to the next. Here we go through, so which interpretation would govern? What we want to do is avoid the barber issue and not have the fraudulent transfer. We want to plan before the storm hits, because honestly, we don't know what's going to happen. If someone starts moving stuff like in a shell game around, there's no telling what the answer is going to be. We always recommend against that. Even if it looks bad, we recommend against that, because there are some options like with the homestead, etc. you can do if you fall into trouble. There's some interesting other cases that involve were there shares issued, and if the shares were issued properly, were they located? And we had a case in Florida where the court refused to attach shares because they were located abroad. And now we recently had a new case that questions that. They wouldn't put the debtor in jail on a contempt claim. In other words, the court could say, you need to bring those certificates back or I'm going to put you in jail on a contempt claim. They wouldn't do that in Florida. So the shares remained outside the country. Then the Florida judgment holder could take the judgment and go to Dominican Republic and try to collect those shares, but of course the shares would be gone, the whole thing. So it kind of eliminated the ability to collect by having the shares in another country, but we don't know. That looks like that may change in Florida. Here's again the Albright. It's a reference to the Albright decision. Single member entities and LLCs in Florida came from this Albright decision, which was a bankruptcy decision, which said that you have to have a second owner to have a protective LLC, even though that was a Colorado LLC, which was pretty protective. What happens is they sit through these trials, or they sit through an entire bankruptcy, and at the end, for instance, in bankruptcy, there was a discharge of indebtedness. That's why you go bankrupt. The court says, okay, we need to get the rest of the assets to the creditors. You've been discharged. You say no. The debtor says no. It's in an LLC. They take a hard look at those LLC assets and everything else. Bankruptcy is really not a great option in general. And this is the Florida case where the single member LLC was certified, whether or not it's protected. They eviscerated all protections. We ended up with a statute afterward that protects only the multi-member LLC. We used to use a lot of Wyoming. Nevada's fine. Wyoming, but Wyoming had a very kind of a disruptive court decision, and no one uses Wyoming. That was kind of the end of Wyoming. And here's a little bit of a wrap up on the single member. If you have any questions, obviously contact me. I want to make sure we cover some of the trust stuff because we're going to run short on time. This is the XIII decision on LLCs, where a very wealthy developer in California set up a family entity of LLCs and was kind of decided to default, it looked like, from the case. It upset the court, and because XIII had done this 99 to me, 1 to my wife, it kind of gave the court a little leeway to say, you know what, we can breach that. We can potentially get to those assets. Our prior ruling that said that action is not allowed for corporations doesn't apply. We're going to allow it, and we don't know what happened when they remanded that back to the trial court. But you don't want to abuse these things, and you also want to set it up properly such that you actually have an operating LLC with real multi-members. Here's a court that rejected the breaching of an LLC in Illinois. Illinois is a little bit stronger jurisdiction. Here's the Offshore LLC. If you set these up and you're not running from creditors, very, very protective. We like to set these up with, sometimes we use foreign assets. Sometimes we put the foreign LLC under a foreign trust. That's an incredibly protective structure. And we also typically recommend that most of the assets held in the foreign structure are held offshore. The NEVA statute limits the fraudulent transfer claim. Also, interestingly, we created that statute such that the actual charging order expires, and that's really, if you have a huge claim and then you register that claim in Nevis and you go through that process, it's possible you can get a charging order, but it does expire. This is a reiteration of the Wells Fargo matter, where we really kind of want to use foreign LLCs in a protective, only a planning scenario. And this, a Sargent versus Al-Sala case, is where we wanted to create certificates, and we may want to put the certificate outside the jurisdiction where the court has, if it's a Florida court, we want to put it outside of Florida, because that court said that we're not going to attach it, we're not going to take it if it's outside our jurisdiction. Now we've had another ruling that questions that, so we'll see where that ends up. We had mentioned keep a portion offshore if we use an offshore LLC, and we may want to put the shares offshore, the certificates offshore. These are some of the characteristics of the debtor-friendly LLC jurisdictions. Limitation on the charging order, no foreclosure rights, operating agreement governs, and there's an absolute prohibition on transfer. So if the owners cannot transfer unless everyone agrees, then someone who takes the membership interest can't transfer, tries to take it, can't transfer either. This talks about the importance of documentation. Obviously, everything has to be documented in the operating agreement. We never want to rely on statute to protect anything. That's very randomized, and the statutes vary from jurisdiction to jurisdiction. And then now we can move into the trust. So a lot of people kind of amalgamate trust with LLCs. Trusts are totally distinct, are not recorded in the States, and some offshore jurisdictions do record trusts or a memorandum of trust. And it's a totally different deal. There's no charging order. So historically, if I put assets into a trust for a relative and I appoint a separate trustee, if someone sues the beneficiary, the relative, there's no claim. If someone sues the trustee, there's no ability to get to the assets. It's very, very protected. The issue that's come up over the years, you have this, every week someone comes into the office with a revocable trust, which is basically a fancy will. It says, I'm already protected, I'm all set. Revocable trusts provide absolutely no protection. They're just a fancy will. You have, in all but 18 states, you have to create a trust that's irrevocable for someone else. And that trust corpus, those assets, are very well protected, typically. We now have the asset protection, to quote, asset protection trust, where you can create a trust for yourself that's protected in 18 states. Florida is not one of those states. There are guidelines and requirements for those trusts, which we'll get into. They're called domestic asset protection trusts. You can make them for yourself. Here's some background. Alaska was the first. We like Nevada. Nevada is very protective, so is South Dakota. Again, Florida does not offer this trust. In Florida, if you create a trust, you have to create it for someone else irrevocably. We have these wild stories where attorneys all over the country are telling the client that they can create a trust for themselves as long as they use a corporate trustee. It's protected. It's not true. Not true. You have to use one of these jurisdictions, not Florida. There's some funny stories. I say funny, but they're kind of odd. They're kind of comical in some ways. There's a few cases they're very interesting. This Huber case isn't as funny, but it's what we want to stay away from. One thing, we want to stay away from bankruptcy, like I had mentioned, because the rules change. It's very hard to protect assets in bankruptcy. And then we want to stay away from some of these domestic asset protection trusts if we don't have a connection to the jurisdiction. In Huber, you had a protector, a co-trustee, all the assets, kind of everything else except for one trustee were in Washington State, and the bankruptcy court, which has a lot of leeway, said, you know what, we don't have a connection to the jurisdiction, the trust jurisdiction. So what we're going to do for public policy purposes, which is kind of hilarious, but this is the way that whole line of cases has gone to bankruptcy, we're not going to allow it. And what does that mean? It doesn't exist. It doesn't exist. So Uber, all the assets are attributed back to Uber and they take them all in bankruptcy. You can't just willy-nilly create these things. You have to, if you want, we like Nevada a lot. So we have, there's a Nevada trustee. We recommend that the assets, like for instance, if you've got a national brokerage, you've got the Goldman account, Goldman, you should use the Goldman asset office or the Merrill office in Las Vegas to create the connection. And we've actually defended a few of those successfully. Of course, again, it's not running away from a creditor. We're actually planning with this stuff. The single member, interesting on the structuring side, because that's kind of what we're doing today. If we have a situation, and a lot of the CPAs can relate to this, where you can't avoid a single member. You just have a client who's going to be a single member. It's precarious as to whether or not that's going to be protected. A lot of times we'll recommend the domestic asset protection trust as sometimes it's very protective. Sometimes we don't know how protective it's going to be, but we do know it's going to be more protective than the single member LLC. So we will add on top of the structure, the asset protection trust, often in Nevada. Mortensen is the Mountain Man case. Mortensen he kind of did a homemade asset protection trust in Alaska. It was more or less okay. It was more or less okay because he's from Alaska. A lot of the issues come up like in Uber where you're not from the state. So it's more or less okay. And all the statute of limitations had passed. What we mean by statute of limitations is we're funding the trust. So we're transferring assets in. And if by any chance something could be considered a fraudulent transfer, there's 4 years for the plaintiff to claim fraudulent transfer after that. Unless they didn't know about it, there's no claim. So all of that had passed, basically. He gets a divorce, and honestly, it looked like she was going to have trouble getting to the assets in the trust. And it was so homemade, though, the whole process, that he claims divorce, bankruptcy. He files, and new fraudulent transfer statute of limitations, 10 years, opens up all the assets. He loses the assets. It's like an unbelievable case. I think it's pretty telling, though. You really have to have good guidance on this stuff. There are a lot of other cases that talk about you have to follow a lot of these self-settled statutes for asset protection trusts require very specific things be done. Some states even require financial filing. There was an affidavit. I think this was Alaska. You have to file an affidavit. There was no filing, so they didn't have the trust. It didn't provide the protections. You have to file the statute. You have to follow carefully the statute. Trustco was an interesting case. The upshot of Trustco, because we're going to run out of time, there was a legitimate litigation, construction litigation in Florida. They won. There was an asset protection trust. And again, if you're with the plaintiff, you want to stay in Florida, because this asset protection trust was formed in Delaware. They filed in Delaware. So the court in Delaware is almost always going to follow the protective language of the statute. And they did. What they did in this case was kind of punt. Instead of doing an analysis as to the applicability of the different protections, they went to the fraudulent transfer statute in Delaware, which had run. So there was no way to collect against the trust. The funding of the trust had taken place properly the time period had passed, that's the end. That's kind of the end of the issue. What we say to people, clients, both corporate and people who are using these entities associated with an estate plan for asset protection purposes, tell the bank, tell the trust officer, tell the mortgage lender, tell the business, the commercial loan officer, let them know in a letter what you did. We've done estate planning. We know there's some restrictions in the loan. We want to make sure everything's fine. Here's what we did. Here's what we funded. You start the statute of limitations. Otherwise, there's an issue. If they don't know, there's always this issue in Florida, for instance, is 1 year after they find out. So the statute passes, they still have a year because they claim they didn't know. So you always want to let them know. Gilchrist Stillman is, again, California. California goes off the rails, but it's kind of a window into what the judges are thinking. This Stillman built a lot of pools for various developments. California, there was some kind of a defect where they leaked, that he got sued. He says he goes flagrantly into California court. You know, I did this Nevada work. I don't have anything. He renegotiates the settlement. Really upsets the court. Court completely ignores the statute of limitations. They say, no, we're throwing everything out. You're in trouble. Totally unnecessary. But just tells you, you got to be careful. Create your protections, get everything in place, follow the rules, and then if something comes up, you simply hire counsel, and they work all the parties through all the protections. You get the big, everyone in the room just kind of rolls their eyes back. Oh my God, let's settle. This is a mess. And it works. I can tell you it works very well. We get into foreign asset protection trust. My screen's blocked a little. I'm sorry. That's why I have a little delay sometimes. And the foreign is extremely protective, but it's not domestic. It's not domestic. It's not as easy to deal with. It's not as convenient in some circumstances to deal with. And we almost always recommend that you keep a portion of the assets offshore. The assets in a foreign trust offshore are not within the jurisdiction of a U.S. court. It's unbelievably protective, but there's a lot of exoticness to it. We work through a couple of the reasons here. For instance, on domestic, there's the Full Faith and Credit Act. So although it's more convenient and the statute is going to be more familiar to a U.S. court, it's subject to the Full Faith and Credit Act, which says if I have a judgment in one state, I can record it in another state, and that state must allow collection on that judgment. If you have a judgment in Florida and you're trying to collect something in Cook Islands, there's no Full Faith and Credit. Their recordation requirement is their recordation requirement. If you don't satisfy it, you're out. It's very protective, the foreign trust in that regard. It's totally outside the jurisdiction. It's more exotic though. It's not for everyone. Oftentimes clients will have both. They'll use the domestic for less exotic issues and then have a bomb shelter offshore asset protection trust. For instance, we have a number of M&A transactions going on. The numbers have gotten crazy. So the client is going to get the 100 million, and there's an indemnity obligation. If the fund mismanages the business and they lose all kinds of value, they'll claim an indemnity, even though it may not be the fault of the client. We want to have a block of money in the offshore trust because it's just not going to be available on the indemnity. In general, it's not going to be available on the indemnity. It's just one of the examples we use the foreign asset protection trust. We go through some of the issues. The way a court accesses a foreign asset protection trust is a fraudulent transfer. So if you have a fraudulent transfer like you did with Wells Fargo and the assets are here, they're going to use the fraudulent transfer act. In Wells, they didn't even use the fraudulent transfer act. They just completely ignored the whole thing and took the the Florida securities account and everything else. We're going to come up on our time frame. These are some of the different jurisdictions available for foreign trusts and some of the pluses and minuses. It's an older chart. Some of this is slightly changed, but it gives you a good idea. You can also, on the kind of the keys to success, you don't want to abuse these things, either the LLC or the trusts. You don't want to give a beneficiary excess control over these assets. You want these to be discretionary trusts. You can have a protector so that money, if you're worried about money's coming out or a bad trustee, we've never had this, but you can have a protector. And the protector has to agree to every distribution. And you can't allow the beneficiary either with a trust situation to just get to assets, or in an alter ego situation, an LLC, where you're just using the LLC to pay your home electric bill. These are just obvious basics you want to avoid. You want to create a link to the between the entity and the people. This is where the people, where the assets. Avoid excess control. Avoid bankruptcy for sure. Don't be egregious. Some background on tax. We got about 2 minutes, which, you know, I'm not sure we could cover the tax bound in 2 hours, but just to give you some basics on the income and estate tax side, a lot of times people confuse whether or not we're subject to worldwide income tax. We are. U.S. citizens and residents are subject to worldwide income tax. Non-citizens are subject to U.S. income tax only on U.S.-based income. The same is true in estates. Worldwide, citizens and residents, only U.S. assets are going to be, only certain U.S. assets are going to be inside a foreign, non-resident, non-alien, taxable U.S. estate. It's very significant, even if it's small, though, because the foreign person does not have a large unified credit, almost no unified credit. Keep in mind that the estate standard for residency, what we're you know, international exposure occurs, worldwide taxation occurs, is different for income tax and estate tax. Income tax, you've got a period, you're in the States. If you exceed your tax on your worldwide assets. Estates, you're here and you intend to stay, whatever that means. So you're here, and the proof is you're not leaving. Then you're taxed internationally by the IRS on your worldwide assets. This is non-U.S. persons on U.S. source income only. That can change if there's a treaty. Different rates for different things. You can buy and sell stock at no cost. There's no capital gains in stock for sale. A lot of people don't understand that for foreign people, non-resident, non-aliens. But that doesn't apply to real estate. And then on the estate tax, one good point here before we wrap up is you can give away intangibles tax-free, stocks and bonds, but if you die with them, they're taxed. All of that should be irrelevant because people who are non-resident, non-aliens who are not coming in to stay should operate everything through an offshore corporation, which avoids estate tax, take and give, if you just hold the corporation offshore and that owns the U.S. assets. And that's pretty much it. This is some grantor status issues with foreign trusts. If we have a U.S. beneficiary, it's grantor, so we don't have any income tax issues. There are some issues with respect to the estate tax. If proper planning doesn't occur, we may have to domesticate the trust.
Gary, as you're making your way to the end slide there, we have one question for you. Why do you advise against bankruptcy, or is that fact specific?
The reason we advise against bankruptcy is because the rules on collection change. That's one reason. So, you know, like we talked about this public policy, the court comes up with, says, okay, for public policy purposes, we're just going to invalidate your trust. And in some of those cases, the older cases up in the Connecticut, New York, most of those cases were, There was no reason to invalidate the trust. There was no fraudulent transfer. They just invalidated the trust, made it available to the. We don't want to get into that. And the reasoning, it's kind of the second reason is the reasoning that the court does that. It's got the right to do it, but the reasoning is you enter the dragon. You go into the bankruptcy court, and the bankruptcy court says, all right, we're going to discharge all this debt. Because we're discharging, there's no guilt for us to just take all the other assets. So we're going to find a way to do it. That's why we avoid bankruptcy. It's really not a great idea. If you don't have assets, it's a great idea a lot of times.
How exactly do rules change in bankruptcy? Does Florida exemption laws apply in Florida bankruptcy cases?
Yeah, the rules that, generally speaking, the bankruptcy exemptions are let's say that this Florida exemptions are respected in bankruptcy. Bankruptcy has its own exemptions, right? Each state decides whether the bankruptcy or the state exemptions are going to apply. That's called the opt-out rule. So Florida's got its own. And generally, those exemptions will be respected. Those exemptions don't include domestic asset protection trusts or foreign trusts. So if you properly funded an annuity or a life insurance policy, it's generally going to be protected. The homestead, which was an unlimited exemption for years and years, and still is outside of bankruptcy, was limited in 2005. So some of that did get limited. So the exemptions remain in general, not the homestead, but the trust and LLC stuff is not. Those are not part of the exemptions, if that helps you. And that's it. Our final slide has our contact information. If you have any questions or you want a copy of either my asset protection book or my book on estate and gift tax for the non-citizen, just let me know. You can call me or you can email me.